This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why a settlement obtained by two lawyers agreeing to a dollar amount can become unenforceable because an insurer lied to the plaintiff about the insurance available to the defendants. And therefore, you must understand that a plaintiff is entitled to know all insurance available to the defendants before the plaintiff agrees to any settlement. Pedro Fundora filed suit against Roberto Dangond and Guevara after sustaining injuries when Dangond struck Fundora with a vehicle owned by Guevara. On appeal, Fundora argued that the trial court erred by granting Roberto Dangond and Guevara's motion to enforce a settlement agreement. In a case entitled Fundora v. Dangond, the Florida Court of Appeals on May 1, 2024, dealt with the request by the plaintiffs to rescind a settlement agreement because the defendant's insurer did not tell plaintiff's counsel about all possible insurance available to the defendants. During litigation, Fundora and Dangond and Guevara's insurer, Progressive Insurance Company, dealt with a demand letter pursuant to Section 627.4137 of Florida Statutes, which provides that, quote, an insurer does or may provide liability insurance coverage to pay all or a portion of a claim, which might be made, shall provide a statement setting forth the information specified in the statute with regard to each known policy of insurance. In response, Progressive sent Fundora a letter disclosing only one policy held by Dangond. Included in the disclosure was a statement certifying that the contents of the disclosure made pursuant to Florida Statute 627.4137 are true and correct. Progressive did not disclose any other policies. When Fundora later offered to settle with Dangond and Guevara for limits, Fundora sent Progressive a demand letter, again requesting disclosure of information on additional known policies, and making the settlement offer contingent on certification that Progressive knew of no other policies. 2 weeks later, Progressive sent Fundora's counsel a letter accepting the settlement offer. Progressive responded to the disclosure demand by attaching affidavits from Dangond and Guevara stating there was no additional coverage. On the same day, however, Progressive sent that letter to accepting Fundora's settlement offer. It sent a separate letter to Fundora disclosing an additional insurance policy held by Dangond and Guevara's co-defendant, Dangond Construction, that may provide coverage for the accident. Because Progressive disclosed this policy after accepting the settlement offer, Fundora did not have the benefit of reviewing the additional policy prior to offering to settle. Fundora's request to Progressive for information on any known policies pursuant to the statute was an essential term of Fundora's offer to settle, with which Progressive failed to comply. A settlement offer, therefore, is unenforceable because despite multiple demands pursuant to the statute and clearly establishing that compliance was a necessary and essential element of any settlement acceptance, the offer of settlement was contingent. Since the defendant's insurer did not provide the information until after one response on the acceptance of the settlement offer, the insurer's failure to provide the disclosure in accordance with the statute rendered the settlement unenforceable because the plaintiff made it clear the insurance disclosure was an essential term and because the insurance disclosure is an essential term under the statute and case law. The Court of Appeals agreed with Fundora that the settlement was unenforceable and reversed the trial court. In my opinion, one of the greatest incentives for a plaintiff to accept a settlement offer from a defendant is the amount of insurance available when the defendant seems to be judgment-proof. That is, the defendant doesn't have separate assets that could provide indemnity greater than the policy limit. When an insurer violates the statute and fails to disclose that there is more insurance that could be available, the settlement agreement was made based on false information, and it was unconscionable to accept a settlement offer based on a fraudulent statement of available insurance, which they obviously knew about since they sent a letter the next day disclosing it. And this video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll be advised of every blog posting, usually 5 or 6 a week, and you'll have access to the more than 4,750 blog postings. You can also subscribe for no cost to the videos on rumble.com and on youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble and the like button on YouTube. And if you wish further detail about insurance, insurance law, insurance fraud, and insurance claims, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.